afternoon. As chair of the commission, I call this meeting of the Michigan Independent Citizens Redistricting Commission to order at 1:06 p.m. This Zoom webinar is being live streamed on YouTube. For anyone in the public watching who would prefer to watch via a different platform than they currently are using, please visit our social media at Redistricting Michigan to find the link for viewing on YouTube. Our live stream today includes closed captioning. Closed captioning, ASL interpretation, Spanish and Arabic translation services will be provided for effective participation in this meeting. Email us at redistricting@michigan.gov for additional viewing options or details on accessing language translation services for this meeting. People with disabilities needing other specific accommodations should also contact redistricting@michigan.gov. This meeting is being recorded and will be available at www.michigan.gov/MICRC for viewing at a later date. The meeting is also being transcribed, and those transcriptions will be made available and posted on michigan.gov/MICRC along with written public comment submissions. There is also a public comment portal that may be accessed by visiting michigan.gov/MICRC. This portal can be utilized to post maps and comments, which can be viewed by both the commission and the public. Members of the media who may have questions before, during, or after the meeting should direct those questions to Edward Woods III, our Communications and Outreach Director for the Commission. He can be reached at woodse3@michigan.gov. For the purposes of the public watching and the public record, I will turn to Department of State staff to take note of the commissioners present.
Difficulties? Are commissioners joining virtually able to hear me? Great. I will repeat that once more. Good afternoon, commissioners, again. Please say present when I call your name. If you are attending the meeting remotely, please announce during roll call that you are attending the meeting remotely. And unless your absence is due to military duty, announce your physical location by stating the state, city, township, county, or village from which you are attending the meeting remotely. I'll start with Doug Clark.
Present.
Juanita Curry.
Present.
Anthony Eade.
Present.
Brittany Kellum.
Present.
Rhonda Lang.
Present, attending remotely from Reed City, Michigan.
Steve Lett.
Present.
Cynthia Orton. MC Rothhorn.
Present.
Rebecca Zatella.
Present.
Janice Follett.
Present.
Aaron Wagner.
Present, attending remotely from Charlotte, Michigan.
Richard Weiss.
Present.
Dustin Witches.
Present.
12 commissioners are present and there is a quorum.
Thank you, Michigan Department of State staff. As a reminder to the public watching, as we move to the adoption of the agenda, you can view the agenda at www.michigan.gov/MICRC. I would now entertain a motion to approve the meeting agenda.
So moved.
Motion made by Commissioner Witches, second made by Commissioner Curry. Is there any discussion or debate on the motion? Hearing none, all those in favor of adopting the agenda, raise your hand and say aye. Aye. All those opposed? The ayes have it, the motion carries. Moving to the review and approval of our minutes, and we have quite a few. The first being June 8th, 2021, our public hearing in Novi. I would entertain a motion to approve the minutes from the June 8th, 2021 public hearing in Novi, which these minutes are also posted on www.michigan.gov/MICRC.
So moved.
Motion
Second.
made by Commissioner Lett, second made by Commissioner Witches. All those, if there's no discussion or debate on the motion. Hearing none, all those in favor, please raise your hand and say aye. Aye. All those opposed, raise your hand and say nay. The ayes prevail, the motion is adopted, and the minutes are approved for the June 8th, 2021 public hearing in Novi. We'll now review and approve the minutes from the June 10th, 2021 regular commission meeting held in Pontiac. I would entertain a motion to approve the minutes from the June 10th, 2021 meeting, which are posted on michigan.gov/MICRC.
So moved.
Motion made by Commissioner Rawhorn,
Second.
second made by Commissioner Lett. Is there any discussion or debate on the motion? Hearing none, all those in favor of adopting the minutes from the regular commission meeting in Pontiac, please raise your hand and say aye. Aye. All those opposed, raise your hand and say nay. The ayes have it. The motion carries. We'll now approve and review and approve the minutes from the June 10th, 2021 public hearing in Pontiac. I would entertain a motion to approve the minutes from the June 10th, 2021 public hearing, which are also posted at michigan.gov/MICRC. Motion
moved.
made by Commissioner Curry, second made by
Second.
Commissioner Lett. Thank you, Commissioner Lett. All those in favor, please raise your hand and say aye.
Aye.
All those opposed, raise your hand and say nay. The ayes have it, and the minutes from the June 10th, 2021 public hearing in Pontiac are approved. Without objection, we'll now begin the public comment pertaining to agenda topics only. Hearing no objection, we'll now proceed with public comment pertaining to agenda topics. A few reminders: individuals who have signed up and indicated they would like to provide in-person public commentary to the commission will now be allowed to do so. I think we have one virtual, is that correct? Yep, one virtual public comment. And at this time, when staff unmutes you and allow a few moments to do so, you will be allowed to address the commission. If you're on the phone, a voice will say, the host would like you to speak, and it'll prompt you to press *6 to unmute yourself. If you are on the computer, you'll be prompted by the Zoom app to unmute your microphone and speak. Also, please note that if you experience any technical or audio issues and we don't hear from you for 3 to 5 seconds, we'll move on to the next person in line and return to you after they are done speaking. But we only have one person today. If your audio still does not work, you can email redistricting@michigan.gov and we'll help you troubleshoot so you can participate during the next public comment period at a later hearing or meeting. Now, I will turn to Department of State staff, who will unmute you and allow our first person. Please introduce yourself to address the commission.
Hello? Are you there?
Yes, we're here. We can hear you.
All right. This is James Gallant with the Marquette County Suicide Prevention Coalition, and my community of interest is the entire United States of America, including this Constitution. And I do hope that you folks are seriously considering the deficiencies in the decision-making processes you are using instead of adhering to the approved Robert's Rules of Order you approved by majority vote at a public meeting. And in order that you would keep the maps that you eventually draw out of court based on process, because that's what's going to happen. They're going to say, guess what, you didn't follow the process, and then they're going to go through it, and you're going to drag it through court, and it may just get thrown out. And I do see that now the first time you've approved an agenda. Thank you for doing that, which all the other agendas were never approved. So that's kind of a problem. And I spoke with the California Commission, Redistricting Commission last week at their public hearing, and I notified them of the controversy that the Arizona-California model has created for the Michigan redistricting process. And they didn't codify their proceedings to the rules of procedure either. Their Secretary of State did the exact same thing, temporary chair, blah, 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 confused, muddied all the rules. There's no mention of rules. I can't even find rules for California yet. That's been, I've been searching for a week. But I did find that California Commission allows the commissioners by law to limit their comments at a public meeting for the public comments. While, like, after I'm done here, every member has a right to address what I'm saying. As a matter of Robert's Rules of Order, they have the right to get the floor and to say, hey, and in California, they limit that to requesting a report from staff or putting it on a future agenda item. And that commissioners can't do that during the meeting. It's in their law. And it's in our Open Meetings Act also, that commissioners, this is, I don't know where the idea came from, but it's in your rules. It says this is not question and answer time when it actually is. All members right now, it appears that somebody's trying to deny the members their legal right to say, hey, I'd like to put that guy's got a point. I'd put that on the agenda. I'd like to have a report. They have a legal right to that. And this commission is denying its members, its own members, it's a legal right. And just trying to keep us all out of court and having to pay for your attorney and then have you lose. So thank you.
At this time, all that have signed up for remote public comment, have for their first turn, have spoken, and we will move to those who have signed up for a second time for remote public comment. At this time, I'll turn the floor back over to the Michigan Department of State and allow our second remote public comment to address the commission for this afternoon. Please allow a couple of moments for staff to unmute you. And you will have 2 minutes to address the commission.
Hello?
Yes, we can hear you.
Are you there now? Can you hear me now? Okay. This is James Gallant, Marquette County Suicide Prevention Coalition again. And, community of interest, of course, entire United States and its Constitution. And this is very interesting that during the opening statements, and the email that I got, there's no mention of signing up for a second public comment. I'm wondering why you folks are not clearly notifying the public about this second opportunity for a public comment, 2 minutes, 100% more, after everybody else is done. And I just don't understand why you folks are not making this clear to the public and thinking somebody's got to find that, somebody's got to fight you over it, and somebody's got to fight you and win over it. And then, there's elderly people with mental disabilities, they're not going to do that. And you know that. But I think it's disingenuous of this commission not to clearly state that to the public. And, there's several issues here that are constitutional. It's about the the process has to be transparent. It has to be, it shows signs of good government and all that stuff. It was kind of, I forget what Dr. Wang, how she put it, she authored this amendment. But I think we're going to have to clear out this part about the Secretary of State being the secretary of this commission, because Robert's Rules of Order, which you have approved, states you have to have 2 officers, a chair and a secretary. And that's the Secretary of State under the Constitution. And she simply is refusing to participate. And you have staff making decisions, actually conducting the elections of the elections official for the state. And this seems to be like getting muddied, and then it's going to go all around the United States. And then, I see a guy on the internet. He says that people are trying to rewrite the rules and reboot the system. And I think that's exactly what some of you are trying to do. I think some of you are trying to just redefine what Robert's rules means. Keep saying you're following it, but you're actually not. And
Mr. Gallant,
say you're
your
doing it
allotted
instead.
2 minutes has ended.
Okay, well,
Thank you to all that contributed to our public comment pertaining to agenda topics only for today's meeting. At this time, our public comment period is over for our meeting, and we have no other comments for this afternoon. Moving to agenda item 6, unfinished business. The commission today has no unfinished business, so we're going to be moving on to new business. We have new business, item A, orientation with Bruce Adelson, our federal compliance. And without objection, I would like our executive director, Sue Hammersmith, to introduce Bruce Adelson. Hearing no objection, Sue Hammersmith, you have the floor.
We are delighted to have Bruce Adelson here with us today. He's going to be presenting on race and redistricting to the commission and to the public listening. He has been hired by the commission as the VRA legal counsel. So he will be advising the commission along the way so the commission complies with the law. So I'm happy to introduce Bruce.
Thank you. And thank you, to the commission and Madam Chair, for inviting me here today. It's a pleasure. And we're going to talk about redistricting and race today. And I'm going to be mentioning a lot of various cases, court cases and other situations. They're really for illustration to give you a sense of what the process is as you turn the corner, so to speak, and the issues that to deal with, how you deal with race, and also how problematic situations can arise in ways that may not seem obvious. So I always like to ask my students and all the audiences that I present to and all my clients the question, what do you do? Because you obviously, this is the first time there's been a Citizens Redistricting Commission in Michigan. Michigan is losing a congressional seat. You have approximately 160 districts that you're going to be dealing with. So I think what do you do is a particularly appropriate question for redistricting going forward. And let's start with something that I think is it's a great historical nugget, if you will, of redistricting in general. Redistricting has been part of the United States at the beginning of the Republic. As you can see, in the late 18th century, Patrick Henry, who opposed the new Constitution, tried to draw district lines to deny a seat in the first Congress to James Madison, who of course later became one of our country's presidents, the Constitution's primary author. Henry ensured that Madison's district was drawn to include counties politically opposed to Madison in one of the first attempts at some type of gerrymandering. The attempt failed. Madison was elected, and I think redistricting had begun. That's kind of a good jumping off point to where we go from there. And for the topic of today's conversation is redistricting and race. Race has always been part of the redistricting process. Being race conscious or race aware during the redistricting process is part of the process. It's not unusual. It's not impermissible. It is part of the process. Having compelling, legally acceptable reasons for the use of race in redistricting is compliance with the Constitution, particularly in our context, 14th Amendment, the US Constitution, and the Voting Rights Act. Supreme Court has been very clear in commenting that these are areas where a consideration of race in redistricting in order to comply with these legal admonitions is not only part of the process, but perfectly acceptable. And that was one of the issues that we litigated 10 years ago with the Arizona Redistricting Commission. We were facing a 14th Amendment, one person, one vote challenge, and the Supreme Court recognized in its 9-0 opinion, upholding our plans, that the commission had in its record clear evidence that what we were doing or had been doing was to comply with the 14th Amendment and the Voting Rights Act. And this is, I think, a good quote from the Supreme Court, which kind of lays out where race fits in a way in redistricting. So the court said, we recognize, however, that the legislature always is aware of race when it draws district lines, just as it is aware of other factors, age, economic status, religious and political persuasion, and a variety of other demographic factors. That sort of race consciousness does not lead inevitably to impermissible race discrimination. I think that's a very important threshold point, that it is, as I said, it is part of the process. It is one of the factors to consider. Indeed, if a redistricting body is not considering race, then they're clearly not starting off on a compliant foot, so to speak. It is an expected, necessary, required part of the process. Going back about 100 years, the US Constitution, according to the Supreme Court, has prohibited intentional government efforts to treat similarly situated people differently because of race or ethnicity. Sometimes the reason for this, for intentional discrimination or disparate treatment is, according to Loyola Marymount University School of Law, old-fashioned racism or stereotype. But singling out racial minorities for worse treatment because of the candidates or parties they prefer still involves singling them out for worse treatment. And it still invites particularly close scrutiny under the Constitution and, of course, the Voting Rights Act. Redistricting legislation typically, and I don't mean redistricting criteria, but enabling legislation to set up whatever body, like the commission, the legislature, to do redistricting, typically doesn't have anything in it about race. It doesn't talk about race. So when you read a statute like that, you might think, well, just race is just not involved. But if the line drawers, as you can see in the second paragraph, intentionally drew the lines to harm residents, to discriminate against them, specifically because of their race, according to Loyola, and I agree with this, that's almost always illegal and potentially unconstitutional. So I wanted to give you some examples of situations from other states, including Michigan, of discrimination in the redistricting context based on race. And one of them comes from the city of East Point. The U.S. Department of Justice 2 years ago, on June 5th, 2019, issued this press release, which in part says, the department's complaint alleges the current method of election for the East Point City Council results in Black citizens in East Point having less opportunity than white citizens to participate in the political process and to elect candidates of their choice to the City Council, which, according to the Department of Justice, violates Section 2 of the Voting Rights Act. And the issue in this case, as I recall, was having an at-large election rather than elections by district. So at-large elections are often seen to be dilutive of minority voting strength rather than have minorities vote or all citizens vote per district. If there are districts that are majority minority, for example, then voters in those districts can often elect their candidates of choice. So that was the issue that the department found here. And I found it very interesting in the court opinion or the court publication of the consent decree that the city did not concede liability. But interestingly, if you read the second clause, the defendants acknowledge that it would be reasonable for the court to find that the three preconditions established by the Supreme Court case are present, but more importantly, under the totality of the circumstances, the United States would have won. So to me, that's another clear indication that while the city may not have admitted liability, the city was conceding that if the case went to trial, the city would have lost. And the court would have found, or a jury would have found, discrimination on the basis of race in violation of Section 2 of the Voting Rights Act. This is a situation in the town of Griffin, Georgia, where they sought to adopt a redistricting plan where only 2 of the 6 single-member districts, so this city elected by districts, there was no at-large election, they had 6 districts. In 2 of them, they would be majority Black, which was struck some, including the people who filed the lawsuit, as unusual because the city's Black population had recently increased 8%, from 42 to 50%. So having only 2 of 6 districts as majority minority raised some concerns. So a lawsuit was filed. In response to that, the city agreed to a new redistricting plan with 3 majority minority districts instead of 2. In the next election under the new plan, 3 African-American candidates of choice won in those 3 majority minority districts. In the town of Delhi, Louisiana, they adopted a redistricting plan that made a big reduction in the Black voting age population in 1 of the town's wards. DOJ, the U.S. Department of Justice, objected to the plan and found that officials had adopted the plan despite the availability of other better plans, meaning non-discriminatory plans. And DOJ found evidence of discriminatory intent, which is a big deal, noting that the reduction was made despite a steady increase in the Black population over 30 years. And more to the point, they adopted the plan despite the town's demographer saying, don't do it, that this is discriminatory, but they did it anyway. And I think that that's where DOJ found some discriminatory intent. So those are all real life, true examples of just a few of them. There are a lot more than those of problematic issues, discriminatory issues involving race and redistricting. So there is a lot of, as you realize, a lot of nitty gritty in the process. There are a lot of details and a lot of digging down pretty far. And I had thought that a really good example, just from a descriptive standpoint, was when DOJ, and actually in my team, when I was with Justice, issued a Voting Rights Act objection to Arizona's legislative districting plan. Now, there are, as I said earlier, some of the cases and some of the situations are somewhat different. And this is an example of the law that you're facing, but the issues are the same. And what I think is really interesting here, which is something that I suspect you may be doing with all the 160 districts. There may be districts that you combine. There may be districts that you eliminate. There may be pieces of one district that you put in 3 other districts, which is what Arizona did 19 years ago. What's interesting is, let's look at in this particular district, Arizona broke down District 22. And under their proposal, they would split that district between 2 new districts, 13 and 14. Now, the Hispanic voting age in the original district was 65%, which is relatively high, but it dropped between 15 and 14 points approximately in these 2 districts, which suggested to us at the time that this might be problematic because such a big drop may affect the ability of Hispanic voters to elect their candidates of choice. We had done, in all the analysis we did, we had determined that historically, a legislative district in Arizona with a Hispanic voting age percentage of these levels, 51.2 and 50.6, Hispanics can elect candidates of choice. That becomes a problem under the Voting Rights Act. That involves something we'll be talking about later on, racially polarized voting and racial bloc voting. So that was part of our objection. So that's something is part, when you think about nitty gritty, they took one district, tore it apart, broke it into 2, but they didn't keep the population the same. They reduced it. And that's where the problem came in. And this is another example. District 23 was the starting point district. 74% of the new district 23 was created out of parts of 6 other districts. One of them was District 7. So 74% of the new district came from District 7. District 7 had this very interesting historical record of electing candidates of choice, but look at that number, 30%. It is very unusual in the presence of racially polarized voting, which there was here, for a minority group to be able to elect at that low an amount. And frankly, that's something I was skeptical about initially. But the people who lived in that district and their elected representatives in the state legislature, particularly the state senator, told me over and over again, provided information and data that even though I disagreed with him initially, we changed our mind, in part because of the information they gave us. They directed us where to look. And when we see each other, which we did a few months ago, we still talk about this. And he still reminds me that, Bruce, I told you, you should have just listened to me from the beginning, instead of taking all that time for me to convince you. But he was right. And what was interesting here is, if you look at the top, the towns of San Manuel and Oracle were historically Hispanic communities, had a significant history of participation in the electoral process. They were taken out of the new district, which raised some concerns for us. They were replaced by two cities, Casa Grande and Apache Junction, which are very different. As you can see, Apache Junction had about 88% white population, very different than San Manuel and Oracle. Well, we kept asking Arizona, why did you do this? Can you show us that this is non-discriminatory? They weren't able to do that. So we objected to this district. And we noted at the bottom that the removal of these towns, San Manuel and Oracle, and the resulting drop in the Hispanic voting age population, remember, 14, 15%, raised concerns regarding the ability of the state of Arizona or the Arizona Redistricting Commission to establish that doing this did not discriminate. They couldn't prove that. So we asked them, we tried to help them in getting information to us that we needed, never got it. And so we objected. So I'm going to talk a little bit about the Voting Rights Act of 1965. We'll have a little flashback in history. Several of these slides are either attributable to DOJ or some Library of Congress or some other sources. So as you can see, by 1965, concerted efforts to break the grip of state disenfranchisement had been underway for some time, but had achieved only modest success overall, and in some areas had proved almost entirely ineffectual. The murder of voting rights activists in Philadelphia, Mississippi, gained national attention, along with numerous other acts of violence and terrorism, primarily in this context, in the context of elections and voting. DOJ's efforts to eliminate discriminatory election practices at the time by litigation on a case-by-case basis had been unsuccessful in opening up the registration process. As soon as one discriminatory practice or procedure was shown to be ruled to be unconstitutional, a new one would come up and DOJ would start the litigation cycle again. Finally, the unprovoked attack on March 7th, 1965, by Alabama state troopers on peaceful marchers crossing the Edmund Pettus Bridge in Selma, Alabama, en route to the state capitol in Montgomery, persuaded President Johnson and Congress to overcome Southern legislators' resistance to effective voting rights legislation. President Johnson issued a call for a strong voting rights law. Hearings began, and then eventually, it didn't take that long, the Voting Rights Act was passed and then signed into law by the president. Just to give you more of a flavor for what the Voting Rights Act has done, according to the Library of Congress, it created a significant change in the status of African Americans throughout the South. The Voting Rights Act prohibited states from using literacy tests and other methods of excluding African Americans from voting. Before this, only about 23% of voting age Blacks were registered nationally. But by 1969, only 4 years after the law had passed, the number had jumped to 61%. So the number had jumped almost 3 times. I found this statement very interesting. It's from Professor Gilda Daniels, Esquire, University of Baltimore School of Law. The Blacks have been in this country for over 400 years and have only been voting post-Jim Crow for 56 years. This is a testament to the power of the Voting Rights Act. It removed barriers to literacy tests, poll taxes, and other disenfranchising mechanisms. according to Georgetown University Law Center, the Voting Rights Act, in addition to removing these barriers, after it was signed into law, was amended 5 more times to expand its protections. And one of the things that I noticed, and I've been watching your hearings and meetings now for the last few weeks, you translate information into other languages, Spanish, Bengali, and Arabic. That's the Voting Rights Act. That's part of one of the amendments after 1965 to bring in language minority groups and people who are limited English proficient. This law has been called frequently one of the most effective pieces of civil rights legislation in American history. So now, with a little information about the Voting Rights Act, let's talk about some of the devices that are used in redistricting and ongoing that are discriminatory. One of them being known as cracking. Cracking is breaking minority populations into smaller groups and spreading them across several districts. And you kind of saw that in the Arizona situation, where they broke a historically powerful district, strong district, into 2, and then made it weaker. That's cracking. Packing is the obvious, and we're going to see an example of that shortly, where you put as many minority voters as possible into a few super concentrated districts, and you prevent the population from perhaps having the ability to elect candidates of choice in other districts. So what would a packing number often would be 75, 80, 85, 90%, maybe even 65%. And that's why this case, I think, is so interesting. This is from 2015. This was part of the last redistricting cycle in Alabama. So in this particular district, District 26, had about 73% Black population. So you might think, that's already pretty high. Perhaps you don't need to add to the Black population from a civil rights constitutional perspective, to prevent discrimination. But interestingly, according to the Supreme Court, Alabama added almost 16,000 new people to that district. Virtually all of them were Black. So if the population began at 72.75, imagine what it became. It likely was, and I don't recall what the court said, over 80%. I think that's a good potential example of packing. And this, when you're looking at race and redistricting, I think these comments from the Supreme Court are particularly informative. Having so-called mechanical racial targets, which is what Alabama did, and saying, we want to have all the majority minority districts, 75%. That's what we want. But you notice that's not based on any kind of analysis. I'm just arbitrarily deciding, it's 75%. So that would likely raise some packing issues, but none of it is based on analysis. Everything about redistricting is based on analysis, based on data, rather than doing what Alabama did and setting arbitrary numbers. When you set arbitrary numbers by race, that raises even more significant issues under the Constitution and the Voting Rights Act. The court stressed that in the second paragraph, relying heavily upon a mechanically numerical view as to what counts as illegal, instead of doing the work, essentially, and having what the court said in the last paragraph, that strong basis in evidence. So here the court said, I think this is also a good illustration of a little bit of the nuance in redistricting. The first quote, how can we maintain present minority percentages in majority minority districts? Meaning we arrived at these arbitrary figures. So how do we do that? How do we keep the 75%? Rather than asking, to what extent must we preserve existing minority percentages in order to maintain the minority's present ability to elect? That's analysis. If my analysis shows that in District 25, the majority Black population can elect candidates of choice with 55%, then why would I have 80%, 75%, 70%? That's not because of equal person, one person, one vote. That's a red flag. All the redistricting plans that I've seen, reviewed, been involved with, numbers that high are always suggestive of potential discrimination and potential problems. And that's certainly what the Supreme Court said here. It's a very strong opinion. Let's talk a little bit about the types of districts. There's a lot of terminology like majority minority districts. So are you required to draw districts that are less than 50% minority? Section 2 of the Voting Rights Act requires drawing new and preserving existing majority minority districts when possible under one person, one vote, but does not require the creation of districts that are less than 50% minority. So if you have a minority population where you can draw a district of a minority population that is a majority, meaning over 50%, then you typically will have to do that. If the minority population is 45%, 38%, 42%, no, you are not required to do that. Whether you choose to do that is another issue. That's a policy choice. It's not required by Section 2. There has been a lot of litigation where the Supreme Court has not required the creation of districts beyond this. Majority minority, if a minority group can be a majority, yes, you need to draw a majority minority district. Otherwise, it's a policy choice. So as you can see, the Voting Rights Act doesn't prevent you from doing that. It doesn't prohibit you drawing these districts. You're just not required to. And I think the last paragraph is important. The drawing the districts that we'll talk about may well recognize that minority population may soon be, oh, am I going too far?
No, we have a question.
Oh,
Bruce, I just
Commissioner
wanted to,
Rathbone has a question.
when we're using, do we have to use, so the last slide, when we were talking about the 50% and it's the, right, and the analysis that we're trying to use, are there approved sort of statistical, like the relevant current data to understand the 50%? Do we have to wait?
There are, and we'll talk a little bit about the analyses, but this is all waiting for the census. So you're right, that it's all population-based and then it's analysis-based. And we'll touch a little bit on the type of analysis that's needed. No, you're welcome. So the last paragraph I think is important because it recognizes growth. Remember we saw those slides earlier where the Black population had grown significantly in, I think, the town in Louisiana and the town in Georgia, but the redistrictors didn't account for that. So this is a policy issue of accounting for population growth, which of course we won't know about until at least mid-August. And we won't know if there are populations in Michigan that have grown, minority populations that have declined. That all comes out in the census data. So this is it cites again to the Supreme Court case, Thornburg versus Jingles, which I'm sure we'll be talking about more as the process goes along. And Nixon versus Kent County, which is a U.S. Court of Appeals for the Sixth Circuit, deciding a Michigan redistricting case. And these are the factors that you evaluate to determine whether or not a majority minority district is required. So the first one, as I said, if a minority group is large enough to be a majority. The second is political cohesiveness. Does this group vote in the same way, essentially? Is there cohesiveness among the people in that group who support essentially the same or similar candidates? And then the last one, whether the white majority voters or white majority votes sufficiently as a block historically to enable it in the absence of special circumstances to defeat the minority's preferred choice. As you can see at the bottom, the second and third, these are called the preconditions, that's racially polarized voting. So the voting as a block to elect, voting as a block to block another group from electing candidates of choice. And these are racial block voting, racially polarized voting, or standard analyses in voting. In fact, before I came here, I was communicating with one of my redistricting clients in another part of the country. And she asked this specifically, is do we have to do this? And my response was yes, because in order to get the Voting Rights Act, check off, sign off, know that you're compliant. Yes, you need to have these analyses to answer the questions that the Voting Rights Act essentially expects. But this is one of those terms, minority coalition district. That's a type of majority minority district, but there's more than one group making up that majority. So it's a coalition. You have here in this example, African Americans, Latinos, and Asian Americans constituting a majority, but neither one of them has a majority by itself. Supreme Court has not ruled whether you have to do this. So as I said earlier, there's a policy choice. You're not commanded to do it. You're not required to do it. That's something that is a policy issue as you go forward. And that may also be informed by your state's new population. What population has grown? Where is the growth? Which has declined and where are the declines? Crossover districts is another example. In these districts, minorities do not form a numerical majority, but can still reliably control the outcome of an election, with some non-minority voters, quote, crossing over, unquote, to vote with minority group. And sometimes, and this was true in Arizona, that you can have, just like that district I had mentioned before that had 30% Hispanic population. That's a crossover district. It's also, it was not a coalition district because there wasn't enough minority population to form a majority. But in that district, Hispanics and whites, a percentage of whites work together to elect preferred candidates of the Hispanic population. So here too, the Supreme Court held in 2019, Voting Rights Act doesn't require this. So you don't have to do this. It's, again, a policy choice. It's something to evaluate as you go forward. And influence districts. This is where there's a large number of minority voters, but fewer than would allow the minority group voters to control the election, meaning that they can elect their candidates of choice. But arguably, they can influence the outcome depending on various factors. And whether or not, if you decided, again, from a policy standpoint, that you wanted to have influence districts, the number or proportion necessary to allow this group to influence or shape an election is determined by election analysis, a review and analysis of past Michigan elections. Remember, I had told you that one of the things we did at Justice with Arizona was determine historically at what rate can Hispanics elect candidates of choice. And we had determined that that number was around 65%. So that's part of what's done in the analysis that I'm referring to. And right on cue, election analysis required by the Voting Rights Act, racial block or racially polarized voting analysis. And I took a slide from your racially polarized voting expert, Dr. Lisa Handley, in a presentation she gave to the National Conference of State Legislators. And I think the questions in bold are her questions. And that kind of informs exactly what this analysis is. So you analyze voting patterns by race or ethnicity to determine if voting is polarized by race. And if proposed districts offer minorities an opportunity to elect candidates of choice, which is the Voting Rights Act. Why do you do it? To ensure compliance with the Voting Rights Act. How is the analysis conducted? It's a statistical analysis of voting patterns. We'll talk a little bit about, and I'm sure that you'll be hearing a lot from Dr. Handley and Kim Brace about exactly what this is. When should the analysis be conducted? Certainly prior to a final redistricting plan being adopted. I always recommend doing the racially polarized voting process relatively early in the process, because that kind of informs where you want to go. It gives you a sense of where the state is generally as far as racially polarized voting, potentially areas of the state to look at. So doing it, excuse me, relatively early in the process, I think is always a good idea. This is a quote from Dr. Jonathan Katz at Caltech. He was also a racially polarized voting expert and election expert. The key statistical analysis needed to comply with the Voting Rights Act is to estimate the voting behavior of various racial and or ethnic groups from aggregate election results to see if there is racially polarized voting. So if you look at election results in Michigan in 2018, for example, at the state level and the congressional level, that's an aggregate election result. You know the winners of all the elections. But looking at whether any election had racially polarized voting involves that digging deeper that we talked about earlier, that's getting into the nitty gritty and doing the statistical analysis that I had mentioned. So just knowing a winner of an election really doesn't tell you anything other than who won. Getting beyond that is the key to redistricting, not only compliance with the Voting Rights Act, but the 14th Amendment as well. This is a good quote from Professor Crum, published in the Duke Law Journal, that racial bloc voting need not occur in every election in the district. And the victory of a minority candidate in a particular election doesn't mean there is no racially polarized voting. So one of the things that we did in Arizona, we had robust election analysis. We looked at tons of elections. Sometimes we looked at elections at among the lower levels at the county, whether it's a school district, or in Arizona, they have community college districts where they elect, just to give us an answer to these questions. So where you may have a minority candidate winning, that doesn't necessarily mean there's no racially polarized voting. We need to do the analysis to see, was this the preferred candidate of choice of the relevant minority community? So as I said, we had robust election analysis. We kept looking at election results relatively close to the time that the commission adopted the plan, just to ease any uncertainties, to cross all the I's. I'm a firm believer in doing that. So we always had a ton of analysis at our disposal, which informs this slide. I love this. I looked for as many pictures as I could find of redistricting commissions actually doing this. This is like the only one I found. And this is from Arizona 10 years ago, but it shows you what happens in real time. Not only are you deciding where to put the lines in the cities, but you have people in the audience giving their thoughts. You have the lawyers opining. You have your RPV expert. You have your map maker. Now, one of the things that we would do if, for example, the man in the yellow hat wanted to keep where he's pointing, let's say that little corner in the district, if there was a large minority population, we would ask the map maker to pull up the election results. And he'd show on the right side of the screen, show us the winning candidates by party, show us registration by party, because Arizona also has a political competitiveness requirement. And that would all scroll down on the right, which is really helpful in real time to see, well, if the commission does this, then this will be the result. This population will change. This level of competitiveness will change. And we would also often have representations of districts like this, showing total population, breakdown by race, and then on the right, voter registration by party, to give an early sense, oh, this is a district that has a 9% Democratic voter registration. Does that raise issues? Is that something to look at from a competitive standpoint? And the racial information is, of course, always important for the issues that we've been discussing, the Voting Rights Act and the 14th Amendment. I think one of the last points I wanted to make, although this isn't necessarily a point about race, the one person, one vote standard requires almost absolute numerical equality among congressional districts. That is not the same for state legislative districts. You have a little room to maneuver up to approximately a 10% deviation. So the court here agreed with the United States in the United States' argument that one person, one vote standard is like way above everything else. Everything is informed by that. It's not something to look at, like with compactness or contiguity is like the gold standard of requirements, with the Voting Rights Act being just below that. So, but I wanted to mention this, the equal population. Yes, for congressional districts, absolutely, as close as equal as possible. For the state districts, not so much. If you wanted to have equal population and that didn't interfere with Voting Rights Act issues, that's also a policy choice. That will be determined as you move forward, you have the data and all the analysis is done. And to close, I love this. One of the issues with using race is that race cannot predominate. That like Alabama, you can't go in and say, hey, we want 75% in all these districts, just make it happen. So clearly then race is predominating, with that 75% in my example being the Black population. So just arbitrarily saying 75%, that's what we want to see. That's where issues of race predominate, that is unconstitutional. So looking at the issue of race in particular, think about driving a car. It's important we all drive cars, keep to the speed limit. If you obsess about your speed and stare only at the speedometer, we know you're going to get in an accident. But if you pay attention to everything, the road, traffic, directions, signaling when you change lanes, car temperature, gas you have, the weather, what music you're listening to, and you occasionally look at your speed, then attention to speed does not predominate. And in the redistricting context, if you're looking at race, as we discussed, as part of what the Supreme Court says in the Hayes case, as one of many factors, then you're likely not going to have race predominate. So that is my presentation today. I hope that this has been helpful. I will be here all day. I'm not going home until tomorrow. And I hope we have the opportunity to chat. Are there any questions? Yes.
All right, so bear with me for a second. This is something I'm struggling with, particularly in Wayne County, in terms of where we draw the lines, because we're hearing lots of feedback from people basically on 2 points. One, urban wants to stay with urban, and then two, people want compact districts that don't cross county, municipal, whatever lines. And so when I look at the population in the Detroit area, you have roughly 700,000 people, 800,000 people. The population itself is maybe 70 to 80% African-American. I think on one hand, you could make the argument, well, that would be easy and logical to just draw the city of Detroit as one district. But then from what I'm understanding from this, you're going to end up with a potentially 70 to 80% African-American district where we could branch across county lines and go up into Macomb County or into Wayne, further into Wayne County and Oakland, and maybe have a district that's 50, 55% African-American, and is more balanced, but is still giving that minority the chance. So I'm trying to understand if we ended up saying, let's keep Detroit together, is that effectively packing, even though the reason why it's packed is because there's a preference for people to live in a particular community, versus should our goal be, let's worry less about staying within one county and worry more about making balanced districts? Like, where do we draw the line on that? Because I'm really struggling with it.
Yeah, that's a great point. I understand that. That's also one of the things that we'll have to see what the census data shows. But I think that that's definitely a consideration. I know that there's often, and in watching your hearing, people often express the importance of keeping counties together and towns and cities together. That's also, I think, at the bottom of your redistricting criteria. And the issues of one person, one vote in the Voting Rights Act are superior legally. So there, as I had said earlier, and I really think this is important to stress, where you put counties, cities, lines, impacts everything as far as race. So I could draw a district that, let's say, is just as Arizona did, that is a majority minority district, but I've added to that an 88% majority white city that is experiencing rapid population growth. That will likely dilute to some degree the majority, the population, whether it's Black here or Hispanic in Arizona. So I think that that's why I wanted to mention the one person, one vote. You have some play at the state level. Congress, although I think drawing congressional districts is relatively not as complicated as state districts because they're so big. But that is definitely, to your point, I think that's something that I would recommend looking at, because the issue of packing is, as you've seen, can be relatively obvious to spot. Whether or not there's legal packing, meaning legally cognizable packing claim, you have to wait to do the analysis. But when you have populations at 75, 80%, that always raises red flags for me as potentially being discriminatory.
Thank you.
Thank you. I have Commissioner Clark and then Commissioner Rothorn.
Yes, I had the same question that Rebecca did, so I'll yield back.
Thank you, Commissioner Clark. Commissioner Rothorn.
So building on that, right, the idea that we could potentially draw maps now, not now because we're waiting to the end of our public hearings, and as we approach July, we won't have the census data. So the question, I think, is to Rebecca and Doug's question, right? This idea that if we can do analysis, I guess the question is, can we do analysis to understand the pros and cons of that? Or do we really have to wait until the census data to actually have true analysis? Or are there other methods, right?
Well, you can do some level of estimating. I think what's interesting, I think I read about this today. The state of Illinois recently adopted a redistricting plan based on the American Community Survey, which is not a per person count. They were sued. And, you know, there's a difference between making estimates and having discussions based on American Community Survey data, based on extrapolated data. It's another thing to draw a redistricting plan based on that, which is certainly not something, I've never done that. And Illinois is one of the first examples I've ever seen of doing it. So racially polarized voting analysis, that can start, that doesn't need to wait for census data because you have election returns. You can get them from whether it's the Secretary of State or the counties, precinct level returns, and voter registration information to begin to understand, well, where is racially polarized voting in Michigan? You know, I think the DOJ settlement with the city of East Point, they had to have done racially polarized voting there, but larger studies statewide or in particular areas like Detroit, Wayne County, Lansing, potentially Flint, for example, Saginaw, that might be helpful because that will inform what you can do in some of these areas. But I think also having policy discussions, as you said, and as Rebecca, I'm sorry, as Rebecca said, if you, instead of having an 80% majority minority district, are there options? Can you do something else? Can you still have a strong majority minority district where the minority group can elect candidates of choice while creating another district that perhaps has a lower majority population, but is still able to elect candidates of choice?
And that would be sort of understanding through the analysis, whether it's a crossover or an influence district potentially. Is that accurate?
Potentially, I think that one of the issues is with where has population declined in Michigan? Where are the biggest areas of loss? What area may be a target for losing a congressional seat? That has to wait. But knowing before, well, where is racial bloc vote? In what elections has that occurred? In what jurisdiction? I don't know the answer to that because I've never seen any statewide RPV analysis to give me an answer. But I think having that information will inform the discussion and what you have. I think good policy conversations, just as you're suggesting. Well,
Thank you so much. We have another question from Commissioner Ede.
Hey, Bruce, thank you for that presentation. Learned a lot. You kind of touched on this one point a little bit in your presentation, but let's say we wanted to create a majority minority district where the majority minority was not just one race, but it still overtook the percentage of, I guess, the white population in that district. Would that count as a majority minority?
Well, the law is pretty clear. It's clear from, remember that Nixon versus Kent County case? That was in response to a challenge of that the redistricting plan from 10, was it 10 years ago? It might have been longer. Did not create a majority minority district with one minority. The plaintiffs wanted, I believe, there to be a majority minority district with two minority groups. The court said that's not what the Supreme Court allows. There are some parts of the country that, not in Michigan, where you can have a majority minority district of more than one minority group. The Sixth Circuit case says no. I think that was 1996. Now, whether or not there are other plaintiffs who bring other challenges to try to change that, there's no way of knowing that. But right now, the Sixth Circuit decision is consistent with the Thornburg versus Jingle Supreme Court case, that a majority minority means one minority.
Gotcha. And does that number necessarily have to get to the 50% threshold, or would it just be enough to have a majority?
Well, what's interesting is let's assume that you can create two majority minority districts, which I think exist today, that are of one minority group. Let's just assume that. If you decide as a policy choice that you want to create however many districts of 45%, 48%, 49%, or even 50%, with more than one minority group, that's a coalition district. That's a policy issue. Now, there may be some legalities that are implicated as well, but one of the first question is, has population decline affected the two existing majority minority congressional districts? Has there been growth, which I'm presuming there has been among other groups, so that perhaps you could get, if not a literal majority minority district, a 45%-ish majority minority district that's a coalition district of two groups? Perhaps, but that's, as I said, that's a policy choice. The legal issues, I'm sure we'll talk about if they present themselves, but that's a policy issue.
Thank you.
Sure.
And Commissioner Rothorn.
We know that when we were in Dearborn, we heard that they have had to check the census data as white. Thinking about statistical analysis, is it the American, where do you know of data that is more or less that sort of allows us to substantiate sort of that breaking down Dearborn and understanding it as non-white, right? But it's not census data. Is there analysis, or are you aware of somehow, how do we tease that out?
Yeah, that's a great point. In fact, and I watched the Dearborn hearing, and that's one of the things that I was thinking about. I think that in part, that's something that I would respectfully recommend that you discuss with Kim Grace and Dr. Handley. I think there are methods, but since I'm not going to.
Excuse me, I apologize for interrupting. Mr. Adelson, would you mind speaking into the microphone more directly so our viewing audience can hear you?
Oh, I'm sorry. Yes, I'm sorry. So as I said, I'm going to leave that to Kim Grace and Dr. Handley. I think there are other sources of information, but since they'll be doing the analysis, I'm going to defer to them about where they want to go.
Any other questions for Bruce or comments? Oh, Commissioner Ede.
This might be getting into the weeds a little bit, but can you tell us a little bit about what you know about these statistical analysis measures?
You mean how they do them?
Yeah.
Well, in part, I'm going to say that I went to law school because I'm not good at math. So this involves a lot of math and statistics. But I think if you look at it in a very basic way, it's taking any election, getting precinct level information about how each precinct voted and the registered voters per precinct, then analyzing the performance by precinct, and then of course then by voters to arrive at your conclusion. That's how you determine racially polarized voting. In Arizona, for example, since the largest minority group is Hispanic, there's something called Spanish surname analysis, which is an evaluative statistical tool that allows the analyst to extrapolate from voter registration information to determine the percentage of Hispanics who turned out to vote and voted for whichever candidate. So it's an extrapolation, because obviously no one can say absolutely how I voted, how you voted, but that's a part of the statistical analytical tool that's used. These are all analyses that have been well accepted for decades. The Supreme Court recognizes them, everybody recognizes them. So I think that using terms like ecological regression, ecological inference, those are two primary forms of analysis. And I know that there is somewhat of a debate in the statistical community about which one is preferred, which one is not. I've used both of them. They've both been, to me, reliable for what I needed, but I know that there are some strong opinions about which one is preferred. I'm sure that's a conversation that you'll have with Kim Brace and Dr. Handley to discuss these, and they can, because Lisa's math ability is much better than mine. And since she's actually crunching the numbers and doing the analysis, I don't want to take anything away from her. So I'm gonna just leave that to her. She is very capable of addressing this and explaining it in ways that will allow you to start connecting all the dots.
Any other questions or comments for Bruce? Well, we thank you so much for your presentation and spending time with us. That was very informative, and we look forward, glad that you're sticking around for a bit so that we can continue to ask questions and talk with you.
Thank you.
Talk with you on the
Well, thank you
subject.
so much, Madam Chair. It is my pleasure.
You're welcome. Moving on to item 7B, Communications and Outreach Update from our Communications and Outreach Director, Edward Woods III, if there are no objections. Edward Woods III, you have the floor for your Communications and Outreach report.
Thank you very much.
Mr. Woods, just a reminder to turn on your microphone as well.
Can you hear me now?
Yes, we can hear you.
All right. Let me get my presentation on the screen. Hold on just a second. Okay. Want to provide an update with regards to the actual terms of where. Our communication plan focuses on fairness, awareness, transparency, and engagement. And one of the things that I wanted just to present to you today so that we can talk more about it next week, just to kind of set the stage, because we know we have additional things on the agenda. And when we talk about a shared fairness in the redistricting process, one of the things that we've done is we shared the makeup of the commission and the process for hiring and adopting maps. We request Michigan residents to provide public comment. And then we talk about how we address gerrymandering through the 7 redistricting criteria. One of the things that we as a commission would need to talk about and prioritize is something to consider for the next session, or for our meeting next week, is how we will identify and prioritize communities of interest to ensure fairness. When I attend the presentations where you present, whether remotely or whether it's in person, it is a question that continues to come up over and over again with regards to how will we prioritize, identify and prioritize communities of interest to ensure fairness. The second thing is awareness. We want to heighten awareness in the redistricting process. We have had outstanding media coverage across the state that has gone extremely well with regards to our media coverage. We have stellar partnerships with statewide organizations and continue to recruit those statewide organizations. As you know, we've added a toll-free number, which is 1-833-UDRAW, 1-833-UDRAW. In addition, we have billboards, we have radio ads, and we have print ads. But some of the concerns when we go from place to place is how are we ensuring that the John and Jane Doe on the street, whether they're in a rural area, an urban area, or a suburban area, what are we doing to ensure that they know about Michigan's new redistricting process? Currently, we're working with the University of Michigan and Practical Political Consulting to identify voters where internet access is low for a direct mail campaign in July. We also need to identify and recruit credible influencers that reflect Michigan's diversity. And so that's something that we're really trying to key on and focus, because that's something that we think we could do a better job. Transparency, we model transparency in the redistricting process is another one of our goals. And what we've done, we've had public hearings, weekly meetings. We have a robust website. I want to thank Sarah Reinhart and the MDOT staff, the team Nelson, that continue to update the website, make it more user-friendly, and the Constitution. But something that keeps coming up in our communication and outreach efforts is how will we incorporate all public comments, whether they're remotely, whether they're done in person, in the redistricting process. It's a question that keeps coming up from a communication and outreach standpoint. And this is something I thought you might be interested in. At the 8-week mark in Novi, we've had a total of 881 people in attendance, 411 in-person comments, 21 remote comments, and a total of 432 public comments. Whereas our virtual public comments, which come in, these are the numbers on a weekly basis since we started, are 329. So we have a lot of, we need to invest and put a lot more work into our virtual public comments. And we could talk a little bit about that on the next slide with regards to engagement. Obviously, we have our town hall forums and presentations. We have our partnership with Michigan 211, and we're doing Train the Trainer in the public comment portal. But one of the things that came out last night, where we had Commissioners Anthony Eade, Juanita Curry, and MC Rothorn, is to make sure the language relates and engages each audience. What you may use in one audience might not work for another audience. The incentive to participate may be different from one targeted audience to another. So ensuring that we do that. And then residents know how to use the public comment portal is something that we really, really want to key on. Because at this point, if you look at the slide before, most of our public comments are coming in person versus virtual. I can take any questions, or at this time, if there's any questions, but definitely would like to have give you time to think about it. I'll send you the presentation so we can discuss more later. Thank you, Madam Chairperson. I saw Commissioner Eads.
Commissioner Eid.
As far as how we're going to prioritize communities of interest, I mean, I think that's pretty well defined for us. It's the third thing in our list of priorities.
Commissioner
better?
Eid,
Hello?
could you speak directly into the microphone, please?
Is that better?
Much better. Thank you.
Okay. I said, as far as how we're going to prioritize communities of interest, I think it's quite clear in the Constitution that we're going to have to prioritize them quite highly. It's the third ranked order thing listed on there. So I guess I'm a little confused on why that continues to be a question.
Well, I think Commissioner Eid is the question, and when you have competing communities of interest, which one has a higher priority? Because for so often, some people have felt left out of the process when they did speak up. Their community of interest or their interests were ignored. And so will that happen again in the new process, and what steps will be taken to assure that it doesn't happen?
I see. Thank you for that clarification.
Commissioner Rothorn.
Thank you, Edward, Madam Chair. And then, yeah, Edward, the slide, if you would go back, put the slide up again, because what I like to see is the number in attendance, you know, that we're at 881. And I think that really speaks to the idea that people are listening to, not just, they're listening to us, they're getting that education. And so that outreach and engagement that you're doing, and that we're getting people who attend, maybe choose not to speak, but also are listening and coming away more educated. That also speaks. It's not, I don't think it's just the total public comments, but that 881 really felt like it was in person or important. And I guess maybe it's the in-person attendance maybe that I should be looking at. Is it 411? Is that true?
The 411 is in-person comments, correct?
In-person comments. So the total public comments is 432 and the total in-person attendance is 881. Is that
Correct.
excellent? Yeah, I just think that speaks to our education and the ability for people to listen to each other.
Thank you, Commissioner Rothorn. You're very astute about making sure we breathe and celebrate some small victories. But I also want to make sure that we're clear that we have a ways to go in terms of making sure every stone is unturned to increasing awareness, but also engagement in this new redistricting process. And so this is kind of at our halfway mark in terms of where we are. But I don't, you know, as we acknowledge what has been going well, I also want to make sure we're realistic that we have a long ways to go. One of the things
Curry. Oh,
I'm sorry. One of the things I do like to recognize is an idea that came from Commissioner Lang, and it's going to county fairs or unique spots in different communities across the state. We have purchased tablecloths, so we have for our display booths, and we're working with MDOT to help us with our pop-up banner that will go on top of the table, and working with our consultant to developing one-pagers that will have a shelf life after our public hearings. So if anyone is interested in following what Commissioner Lang is doing in their respective areas or interests, let me know, because this is an opportunity that's available to all the commissioners to ensure that we're looking at, you know, the festivals, the fairs, the unique things that take place that make a village or a town special are also great places to go. And so many hands make work light. And so we would love to have anything that you think is unique in the community you live or where you may have grown up in Michigan to be a part of that process.
thank you, Edward. Any other, or I'm sorry, Juanita, did you?
My question is to Edward. I've heard Rhonda speak of the rural areas that did not have internet service, and they didn't have ways of hearing about the commissioners, the redistricting plans. And also we went to a place in River Rouge yesterday where the 417 zip codes have not been able, some of them are not able to hear about the redistricting plans. And I'm wondering if there's some way that we can send some kind of mail to them, to certain zip codes, so they can get this information, so they'll know what to do.
Absolutely, Commissioner Curry. One of the things on our awareness is working with University of Michigan and practical political consulting to identify lists. We're identifying voters where internet access is low. So it's not limited to just rural areas, but also urban and suburban, to identify a list, to get a credible list, and then engage in a direct mail campaign, which was approved by the commission, but suggested by Commissioner Aaron Wagner. So yes, that would include the downriver area.
Thank you, Edward, and Commissioner Rothorn.
I just want to say, I want to sign up for what you mentioned with the ban and
Thank
so
you.
forth. Thank you.
Any other comments or questions regarding the update from Communications and Outreach? Hearing none, we thank you, Edward was the third, for providing that that update and continuing to do outstanding work to make sure folks hear about the MICRC and our endeavors. The next item on the agenda is our budget update as of May 31st, 2021, and that will come to us from Sue Hammersmith. And if there are no objections, hearing no objections, Sue Hammersmith, you have the floor to talk to us about the money.
Thank you, Commissioner Kellum. An updated budget was provided as of May 31st. As you will recall, at our May 6th meeting, we amended our budget. So that is the approved budget as amended that is presented. Very quickly, I will just go over one of the line items so you can see exactly how this budget works. So the first line under expenses happens to be commissioner salaries. The first column lists what has already been spent year to date, and that is our fiscal year through September 30th. The next column shows the confirmed, that is the amount that will be spent through the end of the fiscal year. The third column then is the total expended plus confirmed. If there would be any additional projected expenditures, those would appear in the next column, and this would add up to the total approved budget. There are also some notes in the notes column that further explain each detail. There's also at the very end an estimated services provided by MDOS. I just want to report that I took the end of January expenses and doubled them because those were 4 months out, and I added an additional 4 months to approximate what the totals are as of May 31st. But I think we need to recognize that in excess of $700,000 will be provided to this commission by the Michigan Department of State, and we appreciate that support, both in persons, because we get a lot of support from the people at MDOS, but also the financial benefit that they provide to this commission. And without them, our budget could not be balanced. So I would entertain any questions you might have on the budget.
Commissioner Clark.
Yes, I've got a number of questions. First one's to Sue. When you say additional $742,000 from MDOS, you're talking about $742,000 worth of services, not dollars. Sure.
Some are dollar expenditures. I mean, they're all services provided to us, but some do involve staffing. Some involve the procurement of the public comment tool. Those are the services provided, yes.
Okay, great. Let me use the line item public hearings as an example. We have, through May 31st, we have spent $57,000. Okay. Now, is that $57,000, is that paying for facilities up front? Or because we never had any public hearings till June, Or do we still owe the money for all the public hearings?
We started May 11th in Jackson. So our first
Okay,
public hearings were
okay.
the week of May 11th. There are some deposits that venues require us to pay in order to secure the facilities. Some of the bills have been paid in full. This also includes AV costs. For example, we had to purchase security separate from the facility in Jackson. That includes that cost. But I will tell you, these bills lag. So there's very little of our bills paid at this point because we're waiting on invoicing to come in from most of the public hearings.
And that lag leads me to my next question. I mean, what I don't think we want to get ourselves in a position of, and I don't know how we manage this, is that we get down toward the end of the fiscal year, which is 3 months away, and still have these bills lagging. And now all of a sudden, those expenses are going to flow into next year's budget. Because we're not going to be able to pay them off of this year's budget. So how do you feel, or how do you think we should manage that at this point?
Yeah, your staff will make every human effort in order to make sure that any expense that has been incurred is spent within this fiscal year or shortly thereafter. So if a service occurs on September 29th and our fiscal year ends September 30th, the Legislative Services Bureau will still allow us to pay some of those bills a couple weeks into October because they are truly expenses from the previous fiscal year.
Okay, so we have a couple weeks leeway as we move forward.
We will.
Okay. Yeah, I just don't want to see a lot of these dollars float in the next fiscal year's budget.
We don't either.
No, I know you don't. Yeah, I just wanted to understand how it was being managed. If you go to a line item called Communications and Outreach, which is on the second page, I think we have a similar situation, do we not?
We do, and if you'll go to the far column under notes, we have a significant amount of that that's confirmed or committed. So we've already committed over $200,000 of that budget with current contracts. A lot of those contracts are going to be spent within the next 3 months. So I'm confident that that's a pretty accurate number.
Okay, yeah, I just want to ensure that we manage that the same way as that other line item that we discussed. Okay, I yield back.
Thank you, Commissioner Clark, and thank you, Sue, for being so diligent. I also have a question from Commissioner Lang. Commissioner Lang.
I have a hypothetical question. If the Supreme Court turns down our request for an extension, that means we will have to have those additional hearings in this this financial year and not the next. So what I'm wondering is, are things being done, are plans being made in case if that happens to know if we have the money since it was not budgeted for this fiscal year?
Yeah, I anticipate the work of the commission will be the work of the commission for this fiscal year, somewhat regardless of the Michigan Supreme Court decision. We're going to have to continue to do our work regardless. So may we speed up some of the work ever so slightly? That's possible. But we have a commitment, we have a timetable with our mappers and with our consultants. Those are our largest costs. So I'm assuming that this is a pretty accurate budget for this fiscal year.
Okay, I'm talking about the hearings that need to be done after we draw the maps. If I'm understanding correct, those are not budgeted yet? Am I wrong?
Yeah, I don't know how we can conduct hearings when we have not yet received census data. So I don't think there's any way for this commission to humanly have maps ready on September 17th. So I do believe those expenses will end up in the next fiscal year.
Okay, I'm going to yield back. That doesn't really answer my question, because if the Supreme Court turns down our request, then constitutionally, we have to have them done by a certain date. So that's what I'm asking, I guess, is hypothetically, if our request is turned down. Obviously, we're going to keep doing the work. We're bound to do our work and we're devoted to doing our work. But I just want to know, are any steps being made just in case if this happens? I guess, but I'll yield back.
And I would still tell you that it really is humanly impossible to do a good job of drawing the maps until we have the data. So if the Supreme Court should turn this commission down, I'm assuming the commission is going to do its utmost to do as much work as possible in a timely manner. However, I believe this commission will have to wait until they receive the census data to finalize their maps.
Commissioner Wagner.
So basically, Sue Ann, I think what Ron is asking is, do we have the money budgeted for those hearings after the time in which we draw the maps? Theoretically, if it does not pass, is that money already budgeted, or is that money we're going to have to go looking somewhere for? It's not a case of drawing the maps. Is the money available, or has it already been budgeted for those meetings for after, when we're going around getting public hearings for after we draw the maps? Has that money already been budgeted, or do we need to hit the streets looking for some?
The second round of public hearing monies, it would be budgeted in the next fiscal year. We also have $165,000 that is unspent in this fiscal year. It's not allocated to anything specific. So, I mean, there are monies available should the timetable need to be accelerated significantly.
And does that answer your question, Rhonda? All right, thank you.
Thank you, commissioners. Thank you, Executive Director Sue Hammersmith. Are there any other comments? Okay, hearing none, let's move to new business item 7D. And I believe that discussion will be to add Commissioner Clark to the redistricting process committee. And Commissioner Lang, I'll give you the floor.
Okay, I'll be really quick on this one, you guys. Commissioner Clark has been very passionate about coming up with a process to work with our vendors. He's put a lot of thought into it when he brought the motion up last week. And I feel he's got a lot of experience when it comes to processes. And since the commission has allowed 4 members to be on subcommittees and on recent subcommittees, I would like to move to expand the membership of the redistricting process committee to add Commissioner Clark as the 4th member.
Support. Second.
I have a motion made by Commissioner Lang, second gave by Commissioner Lett. Is there any discussion on the actual motion?
Does Commissioner Clark accept this request that he be appointed?
Commissioner Clark, do you have any thoughts? We hate to call you out, but it involves you specifically. So is this something that you would like to do? Would you like to be a part of the committee?
Yeah, I will accept it.
Okay, so once again, the motion was made by Commissioner Lang, a second by Commissioner Lett, and Commissioner Clark has importantly agreed to be a part of the committee. Are we ready to vote, commissioners? All those in favor of adding Commissioner Clark to the committee? Oh, I'm sorry, Commissioner Wagner, please share.
I was ready.
Oh, you were excited. Got it. Okay, all those in favor to add Commissioner Clark to the committee, please signify with raising your hand and saying aye. Aye. All those opposed, raise your hand and say nay. The ayes have it, the motion carries. And Commissioner Clark, you are officially a part of the committee for the redistricting process, which I think makes all of the sense, and you will definitely play an important part. So Commissioner Lang, thank you so much for getting that on the agenda. Moving to our future agenda items, if there is no objection, I'll have our Executive Director, Sue Hammersmith, come to us and talk to us about future agenda items. Hearing no objection, Sue, you have the floor.
Thank you, Commissioner Kellum. Just letting you know that next Thursday, as in 2 days from now, Kim Brace will be back to do his second session on the data cube of 4. So he'll be with us 4 weeks on Thursdays. I'm hoping to also have some discussion with the commission about your reflections on this listening tour. So I will have some discussion questions ready for you. And then next week, again, Kim will be back, and I want to talk a little bit about fairness and decision-making and consensus decision-making. So those are things that we're thinking about for the future agenda items as we commence our business now on Tuesdays and Thursdays. Thank you.
Thank you, Sue. Commissioner Clark?
Yes, could I suggest, Sue, that we give Kim Brace some additional time since he didn't have his full time last week?
Yes, he is under unfinished business for 15 minutes and another 16 minutes for this presentation. So it's, yes, we're working with him.
Thank you, Commissioner Clark. Any other thoughts? All right, we're going to move further down the agenda. If there are no other future agenda items or discussion, to announcements. Are there any announcements for the good of the order?
I was,
Commissioner Eid?
thank you. This is neither here or there, but I was just looking at the current congressional map, and we're right on the, like,
Commissioner Eid, could you please speak directly into the microphone?
sorry. This is neither here or there, but I was just looking at the current congressional map for where we're located today at the Fellowship Chapel at Village Dome. And seems like we're right on the border of District 13 and 14. In fact, I can't even tell if we're in 13 and 14 or 14. We're in one of them, but I just found that rather interesting and something we should keep in mind for later tonight.
Thank you, Commissioner Eid. Sue, it looked like you had something to add.
Yes, I wanted to mention that tentatively, we're working with the Redistricting Process Committee to see if that meeting can be held on July 8th for a full day. So that would be a 9 to 4 meeting. We would allow a break for lunch, but it would be a long work day. And we would work with EDS and our RPV analysts and VRA legal counsel, all of those consultants on that day, and work through our process questions. So we have a clear understanding of how we're going to work together going forward. And
Thank
that
you,
would be in lieu of our regular meeting that we would have been hosting on July 8th. At this point in time, there's no more capacity to add meetings between now and the end of the public hearings.
We've crammed it all in. That's a good thing, I guess. Yep. Edward Woods III.
Yeah, just an announcement. All the meeting in Benton Harbor on July 15th, and I'll send a calendar appointment, will be 5 to 8. The meeting in Traverse City on the Thursday will also be 5 to 8. And then all of the meetings on the college campuses in September will be 5 to 8. So just want to make sure that's clear for the record, and thank you for providing the flexibility at the last meeting.
Thank you, Community and Outreach Director Edward Woods III. Are there any other announcements? Hearing none, is all the agenda items are complete and the commission has no further business. I would like to have a motion for adjournment.
So moved.
Motion made by Commissioner Lett. Second made by Commissioner Curry. All those in favor, please signify with an aye and a raised hand. Aye. All those opposed, raise your hand and signify with a nay. The motion carries. Meeting has been